Today we're going to be talking with attorney Justin Sterling, who will be covering fair use and the right of publicity. And this is a particularly important event for a couple of reasons, in my opinion, which is the first being that people tend to use fair use somewhat indiscriminately and for a lot of strange reasons in order to be able to or they think you can use fair use to use the work of others and not get in trouble for it. And they have a lot of good excuses for that. And it's a mistake that you don't want to make because it can be very expensive. Alternatively, you may find that other people are using your work in this way, and you may realize that you want to make them stop, and you need to understand when they have the right to use your work that way and when they don't. We're also going to be talking about right of publicity, which is important. First, because you may want to be able to do an unauthorized biography. You may want to be able to do a documentary about somebody who's living or dead. You may want to create a fictional character that represents an existing character, a person in the real world. And you need to have some understanding of the right of publicity. The other thing is people may elect to use your image, your name, your work to promote their own work. And you need to know when that's something that's legal for them to do and when it isn't. And so by learning about fair use and the right of publicity, you learn how to protect your work, and you learn when you can use the work and reputation of others to promote the projects that you work on. So with that in mind, Justin, do you want to sort of take a minute or so to introduce yourself and then sort of dive into talking about fair use and the right of publicity?
Sure. I just want to say thank you for inviting me to present, Nancy. It's always a pleasure. I admire everything you do, connecting so many people, bringing so many people together, offering such valuable information and helping so many people. So with that, I just want to say thank you. I am a licensed attorney. I practice entertainment law, intellectual property, and business law. I've done litigation. I've done contracts. I work with writers, filmmakers, producers, documentarians, political journalists all across the world. And this is a very important issue, very important topic. And I'm just going to dive right into it. Again, what I say here, we have our legal disclaimer. It's just for information purposes. If you have a specific issue, feel free to contact me and we can discuss your specific issue confidentially. But the fair use doctrine, you may ask yourself, can you use another's copyrighted material in your own work? Or when can I use the copyrighted content of others legally without licensing it or gaining permission first? And that's where the fair use doctrine comes in. When we talk about fair use, we first have to discuss what is copyright law. Copyright law it protects original works of authorship that is captured in a tangible medium. Okay, that could be text, it could be written, it could be audio visual, it could be choreography now, it could be holographic even. What people don't understand is that as soon as you capture that creative expression in a tangible medium, copyright adheres at the moment of creation. You don't have to register it. It just automatically, you become the copyright owner, all right? You are the owner of that work. However, it's very difficult to prove. A lot of times disputes come down to first in time. Who was the first person to actually create this work? And you probably heard of a poor man's copyright, where they would write their manuscript, put it in an envelope, and then mail it to themselves. And that post date is the date of the creation. And that's the poor man's copyright. It's not very effective. I don't recommend that you do that. In fact, really the only 100% way to protect your work is to never share it. Never share it to others. But that's not what we want to do as creative artists. You want to display your work, you want to exhibit it, you want to exploit it, you want to share it with others. And so the 100% fail-proof way to completely protect your work is once you create it, you put it in your desk and you lock it and you just never show it to anyone. Well, we all know that's not going to happen. So what you should do is, as a general rule of thumb, is when you are sharing your work with others, it should be registered for copyright protection with the United States Copyright Office, the government entity. The WGA is good. However, it doesn't it doesn't provide you with legal rights. All right. Once you register your work with the United States Copyright Office, you get certain legal rights. And the benefits of registering your work is that you get the special legal remedy of an injunctive relief. That means a court can issue a court order to whoever is infringing on your work to stop producing that work and to seize all the means of producing that work. So it's a very powerful remedy because, say, a studio is infringing on your work, you can get a court order to seize all those means of production, all those machines that the studio is using, all the CDs, they would seize that. It halts the production. So it's a very powerful remedy. You also get the benefit of statutory damages, or once you register your work with the Copyright Office. I believe it's $150,000 for infringement, up to $150,000. And that's a benefit because it relieves you of the burden of actually having to prove what your damages are. And in a copyright infringement case, that's very difficult. It's a very difficult task on proving what your damages are. So when you register your work, you get the benefit of having statutory damages. And once you register your work with the Copyright Office, you can get into federal court, a much better venue than state courts, especially for this area of the law. The federal courts are more informed. They come up with more favorable decisions. It's just a better venue. So what you get when you register your work or when you obtain copyright is that you get the exclusive rights. All right, as the copyright holder, you are the exclusive rights holder. And in the next slide, we'll go over what the exclusive rights are. But there's a balance here between copyright law. All right, the Copyright Act, which is the federal statutes, is not necessarily meant to restrict other people from creating work. It's actually meant to inspire others. People want to be inspired from other people's work to create new works. And in society, that helps us progress in terms of arts, sciences, technology. It helps us progress as a society. And so we don't want to be restrictive so much, but it's meant to inspire others, to use other people's work to create new work. However, it is a balancing act because as a creator, you are entitled to your work and to exploit your work. And you should be able to tell other people that they can't steal your work without your permission. So there's a balancing act. Again, go back. The exclusive rights. Once, as the copyright holder, you get the exclusive rights to reproduce, to create derivative works. Those are works that are derived from the original work, spin-offs, sequels. Those are derivative works. You also have the exclusive right to distribute your work. As what I mean by exclusive rights is that you can prevent others from distributing your work, from reproducing your work, and you can prevent others from making derivative works. You can prevent other people from performing your work in public, from displaying your work. And those are your exclusive rights as the copyright holder. But again, there's that balance, and that's where the fair use doctrine comes into play. So whether an unlicensed use of copyrighted material is fair according to a rule of reason, there is no bright line rule. Instead, the courts will view each case on a case-by-case basis. Each case falls on its own facts. However, there are factors that the court will decide to determine if the fair use doctrine applies. And that's the purpose and character of the use of the work, the nature of the copyrighted work, the amount and substantiality of the portion of the work that was used in relation to the copyrighted work as a whole, the effect of the use upon the potential market for the value of the copyrighted work. And we are going to go into some examples. Again, these are the 4 factors: the purpose and character of the use. And if it's more toward research and educational uses or transformative use, it's more favorable to fair use, that the fair use doctrine will apply. If it is for commercial purposes, if you are profiting off of this work, the court will scrutinize the case more closely, and it leans against fair use. The nature of the copyrighted work: if it's factual, if it's historical, it's more fair use. If it's educational, it's more fair use. If it is more of a creative, fictional work, the court will scrutinize it a little bit more carefully. The amount and substantiality of the work that was used. You can't just resell another person's work. I mean, that's infringement. You can't do that. If you're only using a small portion of it, and as compared to the whole entirety of your work, it's more likely that the fair use doctrine will apply. If you're using most of the other person's work in yours, it's going to be more scrutinized. I'm not saying that the court will reject the fair use doctrine, but it's going to be scrutinized more closely. You see, it's a balancing act of these factors. And if it's taken, here's a very critical factor: if it is hurting the market of the other author's work, it will be more scrutinized. If it's going to replace the prior work in their market, it's going to take away from it commercially, then it's less likely that fair use will apply. Okay. Here's some situations that you consider the purpose of the work. If it's more teaching, educational, research, if it's a nonprofit, if it's a critique or a criticism, a commentary, if it's news reporting, if it's transformative as a whole, it's a new product, a new work. These are more favorable to fair use. If it's more commercial activity, if it's for profit, entertainment, if there's been bad faith behavior, or you deny credit to the original author, it's less likely the fair use doctrine will apply. The courts will analyze whether you acted with good faith. If you try to contract a license, if you try to reach out to the original author and try to get their permission to use the work, you have to document your efforts to show that you acted in good faith. It will help you. It will help you if you ever end up in front of the court. The nature of the work, if it's a published work, if it's factual or nonfiction, if it's important to educational objectives, or if it's used in education institutions, it's more likely it will be fair use. If it's not an unpublished work, if it is an unpublished work, that is the former work was unpublished, or if it's highly creative work, art, music, novels, films, plays, or if it's fiction, the court will scrutinize it more closely. The amount, this is a critical point, the amount of the work used. If it's just a small portion of it, not the entire work of the prior author, if it's not the focal point of the new work, if it's just a portion, it's not the focus of the new work. If it's educational, again, it's going to be favored fair use. If you're using the whole work as a whole, if it's the crux of the work, the heart of the work, the focal point, if it's the selling point, then it's more likely that the fair use doctrine will not apply. The effect, if the user owns lawfully purchased or acquired copy of original work, if one or few copies were made, if there was no significant effect on the market or potential market for the copyrighted work, if there's no similar product marketed by the copyright holder, or if there's a lack of a licensing mechanism, it's going to be favored fair use. If it could replace the sale of the copyrighted work, it's taken away from the market value of it, it's likely it's not going to be considered fair use. If it significantly impairs the market or the potential market for the copyrighted work or a derivative work, if it's reasonably available licensing mechanism for use of the copyrighted work. For example, if they have a if they have a licensing agency that is controlling the licensing rights of the prior work, it's going to be more scrutinized. You should have gotten a license. If it's affordable permission available for using the work, again, that comes into the licensing mechanism. Getty Images, for example, they have their licensing mechanism available. You should try to obtain a license, make good efforts to obtain a license, and document your efforts. And if they're not being reasonable with their licensing, if they have an outrageous cost to use the work, if you document your efforts, and a lot of times if you contract with an attorney and get an attorney opinion letter on whether there's infringement, the legal issues involved, if you comply with the fair use doctrine, you should be protected, okay? But it's about protecting yourself, documenting your good faith efforts, and falling within the realm of fair use. Again, it's not a clear line. It is a gray area. It's based on a number of factors, all right? And the courts will look at all these factors. And it comes in, there's two questions that come in when you're dealing with fair use. Was it transformed? Did the unlicensed use transform the material taken from the copyrighted work by using it for a different purpose than the original? Or did it just repeat the work for the same intent and value as the original? You can't just resell the prior work. It has to be transformative. Again, the Copyright Act is meant to encourage inspiration, new works, transformative works. And the amount and nature is a very critical question. Was the amount and nature of the material taken appropriate in light of the nature of the copyrighted work and of the use? If you only use a portion of it in the context of the whole, so much to the fact that it's a different piece of work, has been transformative, it's not the heart of the new work, fair use there's a good chance that the fair use doctrine will apply. So examples of the fair use doctrine is social, political, cultural critique, to illustrate an argument or point, capturing something else in the process of creating your new work, or to provide a historical context, a historical story, or make a historical point. In documentaries, these examples are very applicable. All right. Again, Bo, you must work with good faith. It's very important to proceed in good faith. Document your efforts to obtain a license. Document your efforts to reach out to the owner, and just document all your efforts and proceed in good faith. If you have knowledge that the other author has, if they ask you not to use it, I would get a lawyer involved, get an opinion letter to protect yourself, okay? But document your good faith efforts. There are some misconceptions about the fair use. So for example, if I only use a few seconds of the underlying work, I should be okay. Again, the more you borrow from the prior owner, the more likely you'll be inviting a lawsuit. You can't just resell the whole work, all right? it is more likely that the rights holder will take notice and more likely that they'll feel their commercial interests have been impaired. If you're affecting the market of the prior work, you're going to be inviting a lawsuit. The proportion of the original work that is used is just one of the many factors a judge will consider in a copyright dispute. Another misconception: I got it from the internet, so it should be free to use. Well, we know that's not true. But in today's day and age, in our technology, in the technological era, it's whenever you put pen to paper, the moment a work is fixed in a particular creative medium, copyright exists. All right. Doesn't matter if it's on the internet or not. If it's been fixed in a tangible medium, there is a copyright owner. All right. I'm using copyrighted material, but it's okay because I gave credit to the author. That's not enough. All right. How could anyone claim that you've ripped off their work if you openly attribute it to them? In reality, this is not a automatic defense. In fact, you may bring attention to the work from the author when you credit them. You could implicitly acknowledge that the material belongs to them and that you are infringing on their copyright. So it's just giving credit is not enough. All right. I need to ask permission from the copyright holder first. Well, you do not. By law, you do not if the fair use doctrine applies. You don't have to ask for their permission at all, but document your good faith efforts. All right. But if you fall squarely in the fair use doctrine, you should be protected. All right. And I would recommend everyone to, there is a documentarian statement on the best practices in fair use. And I think, Nancy, you can email all the attendees this document. This is pretty much the standard for documentarians. Documentaries really rely on fair use a lot because they're recording history and they're using a lot of other people's work, putting it in a historical context and retelling history. So fair use is very much an issue when you're dealing with documentaries. So I would highly encourage everyone to download the documentarian statement on the best practices in fair use. It's a free document. You can find it online, just Google it, and it really lays out all the situations. And if you're within, it will go through different scenarios where you may be dealing with issues or you may be in the safe zone. And so I highly encourage everyone to download that document. To protect yourself in all your works, you should get insurance. The insurance that covers copyright infringement is the errors and omissions insurance. That's the type of insurance that you want to get. And a lot of distributors will require that you have that insurance in place. And work with an attorney in order to get the E&O insurance, because the carriers a lot of times will require you to have a attorney opinion letter evaluating your work. And feel free to contact me. I do a lot of attorney opinion letters. I work with a lot of documentaries, and I'm happy to be of service. So right of publicity. This deals with using another's image without permission. Some common questions that you may have is, when can I show a video I've created of living people, like someone yelling in the store about wearing a mask, some current events right now, or talk about living people in my work, or incorporate lookalikes without violating their right of publicity? Well, to address some of those questions, newsworthiness is an exception to the right of publicity violation. We'll get into that. Lookalikes, there's a landmark case involving Vanna White versus Samsung, which involved a lookalike robot. But because of the circumstances, it was implied to be her, and it was obvious that it was her, and it was passing off on her commercial value. Right of publicity is really it deals with commerce, all right, commercial value, all right, and we'll get into that more, but I just want to get into some more questions. A lot of times you may ask if you can incorporate the decedents, people who have passed away, into your work as characters without violating their right of publicity, such as an unauthorized biography of Michael Jackson, Jeffrey Epstein, or a fictional dramatization like Marilyn and Me. And there's a balance here between a person's property right, which the right of publicity is the right of publicity is essentially a hybrid right. It is a privacy right, a economic right, is somewhat of a hybrid right, and it's created by state law. It's not founded in the US Constitution, not through federal law, but by states. All right, state laws have created this right. In each state's laws are different. And we'll get into that a little bit more. But it is a balancing, it's a balance between the First Amendment free speech, creative expressions. And so you have to balance someone's property right versus another person's right to create creative expressions, such as unauthorized biographies or creative works, other creative works. So it's a balancing act between a person's individual right versus another person's First Amendment free speech, creative expression rights. So the right of publicity is the right to regulate the commercial use of your identity. It deals with loss of commercial value, all right? And in order for the right of publicity to be triggered, the person's unauthorized appropriation of an individual's identity must be for commercial purposes. It must be in advertisements, okay? The unauthorized biography is considered in a creative expressive work, not necessarily an advertisement, all right? So the right of publicity deals with when you're taking someone's image and putting it on a good or a product or an endorsement. It implies a sponsorship behind that good or service, all right? And it's protected by state law. Each states are different. California has a right of publicity by statute, and it also protects decedents as well for up to 70 years after their passing. It is an individual's economic right. Again, it's a hybrid privacy right, economic right. And most right of publicity cases involve celebrities, because those are people who are paid for their public performances. For example, Justin Timberlake is going to have more value in his image, his likeness, because he performs publicly. That's how he makes a living, as compared to a layperson, a private person. However, the law still does protect private people, and you'll see that the code, the civil code, the California Civil Code, has a statutory damages provision in there for people who may not have so much value in their image and their likeness. But there's still a right there, and I believe it's by statute, it's $750. It's not much, but still, it's protecting your right of publicity. All right. There are various tests. Again, this is kind of like there's no bright line. There's no bright line rule. Again, there's different factors, and this right has been created by the states. And so each states have applied different types of tests to see if someone's right of publicity has been violated. There's the newsworthiness, the public interest test, the 4-factor test of the copyright law, and the transformative use test. Very similar to the fair use doctrines, all right? Because again, this is kind of like a hybrid right, and the courts had to come up with different types of tests to really find out if someone's publicity rights were violated. It is the commercial use of another's name, likeness, okay? Is the name, voice, signature, photograph, or likeness in advertising, okay? That's the key here. This is the California code here, section 3344. And you'll see there is a statutory damages amount that is meant to protect lay persons, not someone who's necessarily a celebrity. But damages could also be the amount of profits that were made from using another person's image. What is another person's image? It must have a indicia of identity. It's a very broad concept. It's the right of publicity is meant to protect someone's marketable image. That could be your voice, okay? It could be your face. It could be your likeness. Anything that has an indicia of identity, okay? And whether the question becomes whether he or she is identifiable from the total context of the use. Is anything that evokes identity, lookalikes, soundalikes, a nickname, a phrase associated with a celebrity, or such as the landmark case with Vanna White, a robot dressed like the celebrity. Anything that is pawning off, passing off on someone else's commercial value. Again, it must be commerce. This is an economic right. It must be for the purpose of advertising or selling. It comes to say what is commercial. And it's easier to determine what is not commerce rather than what exactly is commerce. And those that are clearly expressive works or newsworthy are protected by the First Amendment. And that's news reporting, commentary, entertainment, works of fiction or nonfiction. Those are expressive works, and the First Amendment protects those. So there's that balancing act between the First Amendment and an individual's economic right. The First Amendment gives least protection to commercial speech. There's different levels of protection for different types of speech. Creative expression is more protected than commercial expression. All right, so there's more protection for creative works than there is for works that are for commercial purposes. If your right of publicity has been infringed, violated, the question becomes, what is the damages? And so it's important to determine how much profit was made by an advertiser and the number of times that the photograph or your likeness or the work that contained your likeness was used. That's very important. And it could lead to a lot of damages. Damages is what could be, is the monetary, we're talking about monetary damages that could be recovered for a violation of your right. There must be an element of what we call in the law scienter, okay? And that's knowledge. And it must be done with the knowledge of the unauthorized use, okay? So if it was merely negligent, that it was done by mistake, it may not be a violation of your right of publicity. There must be that knowledge that the way they're using it is unauthorized. They don't have the permission of your name, your voice, your signature, photograph, or likeness. Again, many states have enacted statutes that protect decedents' right of publicity. It adheres to their estate. California has section 990, and also I believe 3334.1 in the right of publicity statute. They protect the rights of decedents. This is known as the Celebrities Rights Act. Okay, so in California, the right of publicity is still protected for 70 years after the death of the deceased personality. There's case law in there before this statute. The Lugosi case said that this right died with the decedent. However, by statute, it says that the state can assert this right. And there is a difference between the right of publicity and privacy. Privacy rights include defamation, false light, intrusion into seclusion. Those privacy rights die with the individual, but the publicity rights gets passed on to the estate for 70 years after the decedent. Again, publicity versus privacy, a lot of people get confused with a privacy right versus a publicity right. Privacy rights include defamation, and they die with the person, the decedent. Publicity rights deal with commercial and deals with advertising, solicitations, and that can be passed on to the estate. It's an economic right. All right. And here, again, I think this codifies, this is in the California statute, this codifies the balance of a publicity right versus the First Amendment. And these are materials that are considered to be expressive works protected by the First Amendment. And those, the advertisements on behalf of these expressive works may also be protected as well. But it must be an expressive work protected by the First Amendment. It cannot be basically a good, for example, a mug with someone else's image on there that you're selling. You can't do that. That's clearly a commercial violation. You can't profit off someone else's likeness. You can't show that there's an endorsement and a sponsorship of that individual, that likeness to your good. Here are some notable right of publicity cases. You'll get these slides and you can look these up, and they're very interesting cases. We provided the case brief for the Vanna White case, White versus Samsung. It's quite interesting. It's at the end of the slide here. And yeah, I encourage you all to take a look at these, and they're pretty interesting. Again, we talked about different types of speech. There are certain speech that's more protected than other type of speech, and there's certain individuals that may be more protected than others. Politicians, for example, celebrities, private citizens. We talked about celebrities having more value because they earn a living from publicly performing. They basically earn their livelihood from their image, their likeness. Politicians, they put themselves out there and they can be critiqued upon, and so there's not necessarily as much protection for politicians as there are for private citizens. Again, but private citizens may not have their value in their public image, so they may only qualify for that statutory damage. But there's other causes of action as well that you may assert if you are determined that your right of publicity has been violated, such as common law misappropriation. And there's also the Lanham Act and unfair competition statutes and the trademark violation. These are common statutes that are causes of action that are also asserted in conjunction with the violation of the right of publicity. We talked about that balance between free speech, creative expression versus commercial speech, and there's always that balance. The First Amendment seeks to maintain a balance between an individual's right of publicity and free speech rights that allow specific usage of an individual's identity. And the First Amendment produces a hierarchy of protection under the newsworthiness exception based upon how an individual's identity is implemented. And the least protected under the First Amendment is advertisement, where a portrayal of a person's identity is used to sell a product or a service. The newsworthy exception. Basically, the test comes down to is, does this affect the public? Is it a matter of public interest? Is it something that should be critiqued upon? Is it something that is a matter of public discourse? And then If that's the case, then the newsworthy exception will apply. And that's protected by the First Amendment. The First Amendment exists to ensure the public knows about events, people, and other topics that affect the public. The newsworthiness exception includes information regarding real world, which includes current events, okay, public issues, educational, historical material, and entertainment and amusement concerning interesting aspects of an individual's identity. There are two critical questions that you must answer before using an individual's identity under the newsworthiness exception. Is the unauthorized use of an individual's identity really news that is subject to First Amendment protection? And is there a reasonable connection between the use of the individual's identity and the news that is being conveyed? The First Amendment protection protects you in creating those unauthorized biographies because they're considered creative expressions, all right? However, when you're doing those unauthorized biographies, still be mindful of privacy rights, such as defamation. In your unauthorized biographies, you cannot say something that is false, a false assertion of fact that damages another person's reputation, all right? And then you'll see, a lot of these unauthorized biographies come out after a celebrity passes away, so they don't have to worry about defamation. However, I still would be mindful of defaming other people in your biography, such as their children, their spouses, people who are related to them or close to them. They can come, and they're still living, and they could come after you for defamation for the way you portray them. Okay, so be very mindful of that. When you're doing unauthorized biographies, yes, they may be protected by the First Amendment in terms of publicity rights, but you still must be mindful of privacy rights, all right? Pictures taken in a public place that illustrates a newsworthy story can't be stopped by a right of publicity claim. The right of publicity cannot be used to suppress undesired discussion and commentary on a public person's lives. That goes hand in hand with an unauthorized biography. Novels and other fictional works based on actual people and events is not possible if an individual's right of publicity legally prohibits it. All right. So the courts have held that as long as the work makes it known that it is fiction, use your disclaimers in the beginning of your works, all right, then there is no infringement of an individual's right of publicity. Still be very careful of rights of privacy. You got to be mindful of all these different rights. An individual's right of publicity would be violated if the works claim to be factual and it is fiction, okay? So you have to be, you have to tread lightly here. The First Amendment permits a publisher to publish and advertise newsworthy material when that material is about the individual and accurately represents the content of publication. So the First Amendment is a very strong right, but it's not absolute. Again, there's different levels of protected speech, and commercial speech being less protected than expressive speech. However, if there is something that is newsworthy, and the newsworthy exception is very strong as well. This is where the right of publicity violation, this is a common example of how the right of publicity is violated. An individual takes a photo for a modeling agency. Somehow this photo is given or sold to a media outlet who then utilizes the photo in an advertising campaign. The individual in the photograph discovers the photo on a poster in a clothing store where they realize they never gave consent to this company to distribute the photo. The advertising company is now in violation of the right of publicity. The company can be held accountable for any profits made while the advertisement was in place. All right, so that's a common example of how the right of publicity is violated. Photos of crowd is not a violation of an individual's publicity rights unless that individual is singled out. But if it's in a crowd, it's not a violation. It's not it's the crux. What is the driving force here? How is this good or product deriving its value? If it's from the individual's likeness, it's likely to be a violation of their right of publicity. If the value of this new work or this advertisement is from the whole content, you have to take it in context. It's not deriving its value from the individual. Another exception to the right of publicity is the transformative work defense. Again, our Copyright Act and our creative rights are really meant to inspire creation, progress, new works. So if you have incorporated significant creative elements, it has become the publisher's own creative artistic expression, and therefore it will be protected by the First Amendment. But there must be significant creative elements. It must be transformed into something new, into a new work. Take, for example, Andy Warhol, for example. His works were considered to be transformative works. The insurance that is necessary to protect against these type of violations is known as advertising injury insurance. So if you're in that industry, I would very highly encourage you to reach out and get this insurance so you're protected and so you're not at risk of going forward. It's very wise to have your correct insurance in place. E&O insurance, advertising injury insurance, two different types of coverage. And I think, oh, yes, and this is very important as well, the anti-SLAPP statutes. A lot of times when someone brings a lawsuit for maybe copyright infringement or violation of the right of publicity, you can expect to receive a anti-SLAPP motion as a responsive pleading. Anti-SLAPP means SLAPP stands for Strategic Lawsuit Against Public Participation. For example, which essentially means that the plaintiff brought their claim just for the sole purpose of chilling free speech, that it was meant to basically silence you from asserting your free speech. And if that's the case, you file an anti-SLAPP motion. And it's important because you have to really consider, if you're the plaintiff bringing this, you really have to consider whether you have a legitimate case and you're not just doing this to chill free speech, because the anti-SLAPP motion shifts the attorney's fees. If they are successful on with their motion, their anti-SLAPP motion, they can recover their attorney's fees for having to defend against this. So it's you really have to consider whether you have a legitimate claim. Even also applies to defamation. With all defamation lawsuits, you have to really consider whether it's a legitimate claim, because you can expect the defendant to file an anti-SLAPP motion, and you as the plaintiff will be responsible for their attorney's fees if they are successful. And the prevailing party on that motion gets their attorney's fees paid. So that's just an important point to make. And this discussion wouldn't be complete without referencing that as well. You can always work with an attorney. I provide general counsel services, very affordable rates. I work on a month-to-month basis with a lot of my clients. Please check my website out, and I'm happy to discuss more with you. We can have an individual consultation if you like more information. And I'd like to take some questions if there's any, Nancy.
Yeah, there's actually a bunch of really interesting ones.
Sure, yeah, let's go for it.
So somebody asked, somebody mentioned that if you use registered mail, that's a good way to defend your copyright or prove your copyright in court. Is that what you recommend that people do, or do you recommend that when their content's finished, they register at the Copyright Office, or ask their attorney to do it if they're afraid of using the copyright.gov website?
Yeah, the registered mail, the poor man's copyright, I wouldn't recommend that at all. You have to register your work with the United States Copyright Office. Once you register your work, the Copyright Office will submit your work into the Library of Congress, which essentially is the document bank for all expressive works. And you have to get into the federal agency. So here's the rule of thumb is, because a lot of creative artists, writers ask me, well, I'm not done with the draft yet. I'm still working on it. It's in the second draft. I'm going to make a third draft. Should I register it for copyright protection? Here's the rule of thumb. Whenever you decide to share your work to another person, your work should be registered with the U.S. Copyright Office. Whenever you're showing your work to someone else, it should be registered before you show it.
If somebody let's say I have a unpublished screenplay and I send it off and I register at the Copyright Office, and then later it gets infringed upon, you mentioned statutory damages, and you mentioned, I think, is it true that if I have to defend my copyright, go to the trouble hiring a lawyer and so forth, is it true that if I prevail in court, because it's registered at the Copyright Office, I get attorney's fees? So it may be the case that attorneys will be more willing to help me with my case when it's something they see a very flagrant abuse of copyright, if it's registered at the Copyright Office.
But the attorney's fees are by statute. I can't recall offhand if the Copyright Act allows for attorney's fees, but it must be by statute or by agreement. I always don't count on attorney's fees provisions, and this is the reason why, because you need to get it approved by the court. So you have to submit it to the court, and the court has to approve it. Many cases I've had where attorney's fees were permitted, the court denies the motion and just still orders each side to pay their own attorney's fees. So the court, yeah. So that's the court, yeah.
The courts can be very variable about that. And the other question I wanted to ask is, if I register at the Copyright Office, if I don't register at the Copyright Office and somebody takes the screenplay that I've submitted to a contest of some kind, and somebody else changes its name and registers it at the Copyright Office, and I haven't registered it, how do I have to prove that I own it somehow if I decide I want to sue later? And because the reason I register stuff is because if I register at the Copyright Office, it's proof that I own it. And if I haven't let anybody else see it and I register it, then I'm confident that when people go to the Copyright Office, it'll be registered in my name. Whereas if I send it out to 20 or 30 different people and somebody goes crazy and starts to register it, then I'll have lost it, because they'll be the one that has proof that they registered at the Copyright Office, and they'll have the proof in court that they own the silly thing instead of me owning it.
Well, the elements of copyright infringement is access to the work. So you have to show that they had access to the work. You emailing it out there, you can establish that they had access to it. All right. You submitting it, you exhibiting it to them, and they saw it, you can show that they had access to your work. And substantial similarity. That's the second element for copyright infringement. A defense to copyright infringement is independent creation. So, if they independently created something and then registered it, that would be to their defense. But if you can establish that they had access to your work and is substantially similar, then you can sue them for copyright infringement.
Right, but it's just harder because they registered it and you haven't registered it. So that's why you recommend people register their work at the Copyright Office so that it's protected and they don't have to, they're in a much better position to prove that they own the work because it's registered and it was registered before anything else was registered.
Yes, and also with your registration, and that's why you're right, it's going to be more difficult because with your registration, you get certain presumptions. You get presumptions that you are the owner. You get presumptions that it is a creative work of authorship. And those are, you have to overcome those presumptions. But the registered, the individual who registered the work with the US Copyright Office is entitled to those presumptions.
Cool. So one of our members is mentioning that she's gotten notified that a lot of her books, actually whole books, are available on other people's websites for free download. And a lot of the websites are foreign, for example, Romania, etc. And so how are, if that were being done here, she would have the ability to, request that they were taken down, or, but if it's done overseas, how do people that are having their books stolen, can they get damages, the statutory damages if the work is copyrighted, or how does that work in terms of trying to protect your property?
Yeah, international intellectual property rights is another ballgame. There are treaties among countries. I believe the Madrid Protocol and there's the World Intellectual Property Organization. They have treaties. They monitor that stuff. But then there's other countries such as China that won't respect our intellectual property rights, and you have to do defensive copyright registrations, which means that you have to also register your work for copyright protection in those countries as well in order to really protect them. But there's certain countries have treaties, and we respect the intellectual property rights of the citizens of those countries.
Which means that they'll probably have a link, like if it's a European city, they'll probably have a link on the page that says report a stolen work, and then they'll take it down when you request it because that country has enforces copyright.
Right. Also, I think the EU has an EU copyright registration, which will protect you in all the countries with the EU. But yeah, it gets very technical when you're dealing with international intellectual property rights.
Right, and so especially when you're going overseas, if you were going to be, if let's say J.K. Rowling, she has enough money so that if she sees Harry Potter books being put all over the internet, all over the world, she has enough money to go after those folks and have them pulled down, presumably. But for normal people, that kind of thing is fairly expensive. Is it the case that your focus mostly for copyright infringement like that is easier to enforce here in the United States? It's easier to get your rights defended here in the United States, where most of your market probably is, than it is to enforce these rights overseas?
Oh, absolutely. Yes. I mean, you avail yourself to our courts. That's what they're there for.
So what if somebody asks, what if they used a published photo, like a photo they found online, or just a photo from Look magazine or something like that, and they put full accreditation on it and they put it on their blog? Would that be a violation? And you think, does that qualify for fair use, or does that sound like a copyright violation?
I'd have to see how it's being used. Yeah.
Okay, cool.
Yeah.
Let's see.
Again, the fair use is balancing act. You have to evaluate all these different factors.
So if it was your commercial website, that might be one thing. If you were doing a retrospective of 60s heroes, it might be for a school. It might be a different thing, right? Because it has to do with the context of the work. Generally, And then you said you should make an effort to license any photo that you choose to use for the purpose that you're going to use it. If you're going to use if you're going to take somebody's photograph, some photographer's photograph of Martin Luther King, and put it on your website, and then drive hundreds of millions of people to it with advertisements, and it's a commercial website, that starts looking like maybe you should have paid the guy for his photograph.
Hmm. Absolutely. Remember, commercial speech is on the lower end of protected speech.
Cool.
If it's an expression or newsworthy, a matter of public interest, if it's a commentary, if you're critiquing, if you're offering a critique of Martin Luther King, different story, probably protected speech. If you're just putting his image on a product and selling it, it's probably a violation of publicity rights too, and you'll probably hear from his estate.
And also, that's publicity rights, and also the guy who took the photograph, since presumably he didn't take a picture of himself.
Copyright. Yeah.
Copyright. So someone else asks, we interviewed some experts and saved it to our Zoom account. So who owns the work? We created. We thought we own it, even if we give them a copy, and we let them use the edited version in any manner that on a limited, non-competing manner. So who owns a photograph or a video if it's the guy that's pressed the record button, right? Just like the guy who presses the button when you're taking a photograph. Is that correct? Or generally speaking?
Yes, the copyright owner is the individual who actually captures the expression, the creative expression in the tangible medium, the photographer, the videographer, the writer.
And then the second question is, so if she interviewed some experts with an idea and let them know in advance and asked their permission to use their work going forward, or distribute the work that she's creating going forward, so she has their permission or had their permission, then their right of publicity, in a sense, they've said you have my permission, so this stops being about their right of publicity, because they gave her permission to use the work, and if she uses it consistent with what she told them, and hopefully
well, that's why you get image releases on a lot of you're making a film, from all the people being portrayed in your film, you get image releases, and that essentially is releasing their right of publicity, and waiving any claim against you for violating their right of publicity.
Right.
You are the copyright holder by capturing or producing that work. You own the copyright. But all those individuals that are portrayed in your work, you should have image releases from them.
And cool. Well, I think a lot of times on the internet, when you're talking to people, you ask them to give you the permission online. Is it okay if I make this work available going forward? And they say yes, and it becomes part of the finished work. So it's clear that they have the right, but everything should be in writing clearly.
Yes. When contracts, again, we did a great presentation on contracts, but contracts do not necessarily have to be in writing. They can be verbal, but there are certain contracts that are, the subject matter is so unique that they must be in writing. There's what we call the Statute of Frauds that require certain contracts to be in writing, and that we use the acronym MyLegs. Contracts where the consideration is marriage, Y, that cannot be completed within 1 year, the year-long provision. Land, L, land is always unique. Anything that involves land, a contract that involves land must be in writing. A lease, a land sale contract must be in writing. E, an executorship, which is satisfying the debts of a decedent. The executorship agreements must be in writing. G, goods, by common law, goods over $500 must be in writing. By statute in California, I think goods that are over $1,000 must be in writing. And then S, suretyships, the promise to satisfy the promises of another, a suretyship, must be in writing. Those types of contracts must be in writing. And when we're dealing with intellectual property is very unique as well. So contracts dealing with intellectual property should be in writing as well.
Right. Well, I think you mentioned there when we're talking about contracts, when you're doing work for hire agreements, where when people are working for you, anything they create belongs to you, or when you're transferring intellectual property, hiring a writer to work for you, work for hire, or hiring a filmmaker to work for hire, it's important to have contracts because you need to be able to prove that you own the work that was created.
I'm glad you brought that up, and because the audience is mostly creatives, the work made for hire doctrine is very important as well. Work made for hire basically is, if you're an employee, your employer owns the work that you create, or if you have a work made for hire agreement, it must specifically say that work made for hire in your contract. It must have those terms in the expressly written in the contract. You must have those terms. And the work made for hire statute, there's only, I believe, 7 or 9 different categories that fall under the work made for hire doctrine. A lot of producers, because it's part of a audio visual, it's considered work made for hire. But a lot of different type of creative works may not fall under those categories. So I always encourage my clients to not only in their work made for hire contracts to also have assignment provisions. So if it is not considered work made for hire, then the person assigns their copyright, and then also to effectuate further documents in furtherance of that. So if maybe this contract doesn't satisfy the transfer of the rights, the party will sign the further documents that are necessary. It just protects yourself, because that work made for hire doctrine is very it gets very sticky when you don't fall into those categories. There's only a few specific categories in the work made for hire doctrine.
So Greg Quinn has a very interesting question. He
Sure.
says, so I can legitimately write a book about somebody famous. And what if I include an image of that person on the book cover? That's advertising. So I think he's talking about, like, let's say I decide I'm going to do a book about Trump or about Weinstein or about some banker who defrauded 1 billion people.
Well, yeah.
When I do if I do something that's an unauthorized biography or an expose book or story or whatever, and I want to use a photograph on the showing them, there's the issue of what are the issues involved, because you're doing advertising. Are you violating their right of publicity because you're doing advertising on this piece?
And I know we discussed this too before the presentation. And here's my response: is first, you probably will be inviting a lawsuit, first of all. And that's just a consideration. You most likely will be protected, but you will be inviting a lawsuit, which could be very costly. But in California, I believe their code has an exception for that particular situation. Because the unauthorized biography is considered an expressive work, the advertisements in furtherance of those expressive works are also protected. So putting him on the cover would be protected. However, it's a thin line. It's a gray area. Some estate, if it's a decedent, some estates are more litigious than others, and certainly certain public figures are more litigious than others. So it's a balancing act. But I think by statute, I believe you would be protected in California. Now, it depends on what state they bring any action in. Each state is different.
When people are working on unauthorized biographies, unauthorized or documentaries, stuff that looks like it could turn into a lawsuit, or fictional works. Let's say I want to have Marilyn Monroe talking to Albert Einstein about relativity, and I'm totally manufacturing everything. I say clearly it's fictional, but I want to promote it based upon the fact it's got Marilyn Monroe's name in the title. Is whenever I want to do something that it is leveraging this kind of thing, should I start working with an attorney before I publish? So just to, because I am probably going to be, I may be inviting a lawsuit, and I want to make sure that I'm prepared in case such a thing happens.
Mm-hmm.
So it can ward me off, or what?
Yes, I would always encourage you to work with the assistance of legal counsel. Also, good faith efforts. Document your attempts to reach out and get permission. Shows that you're proceeding in good faith. But I do want to just go through the slides and just show that the Vanna White robot.
Yeah, I think it's a really illustrative example, actually.
Yeah. So you see, there's Vanna White, and that's the robot. And again, there's different speeches has different scrutiny and different protection. This was on a commercial speech, less protective than expressive speech. But again, if you're putting that biography out there and you're really pushing it for profits, and the court could consider it more commercial than expressive. It depends on what court you're in. It depends on the jurisdiction. There's a lot of factors to consider. But yeah, I mean, this was a robot. It was on a commercial, but it was clearly pawning off of her commercial value in her identity. She did bring a lawsuit, and the court goes through the analysis, and you can look through the if I go back. Oh no, how do I go back?
Probably just have to use your arrow keys to go back.
Yeah, there we go. You can go read the court decision, and this is just a brief, but if you actually pull up the court opinion, you can find it online. The court's opinion goes through a very good analysis of this. So yeah, it's very interesting.
Seems very cool. So, and I think if somebody had asked, he was a background actor in a film where they used himself and another actor to sell the scene, but I was only given regular day rate for background instead of featured union day rate. When I asked SAG about it, they told me the 7-second rule. Was I on screen for 7 seconds? Not in total, but broken up into 2 to 4 shots. So when you agree to appear agree to have your image or likeness used as for a specific, usually the contract says for a specific purpose or a specific time or whatever. I mean, or it talks about what the application is going to be. And when that's violated, you can go to your union and complain, but if they don't protect you, then is something you can sue about and basically say they did something totally different than they said they were going to do with my name and image when I agreed to be in this picture or in this project.
Mm-hmm. Well, I'd have to review the contract. Mm-hmm. It's really controlled by the contract, the terms in there. So you really have to understand those terms in the contract. Most likely, you released your right of publicity for any purpose.
Mm-hmm. So, let's see. There's some other questions here. So people are should reach out to you. We should go back to the first slide so people see your email address. There's a couple of questions here that are very specific, which I don't want to dive into because I don't want to put us in a position to, I don't want to put us in a position to dive deep on specific details for a particular topic. So there's a question in here about so Trump can't, if I decide to do a documentary about Trump, because he's a public figure, he were to try to stop me, try to shut me down, he might be a candidate for an anti-SLAPP lawsuit because he's clearly a public figure. I clearly have the right to do an unauthorized biography. And I get more of a right because he's newsworthy. So the anti-SLAPP thing is to make it so that people who are public figures can't silence people talking about them by just doing a bunch of spurious lawsuits.
Mhm.
Is that correct?
That's correct, but you would have to be very mindful of defamation in your biography,
To make sure it's
and
accurate.
yeah, accurate. You really have to support it with your sources,
Mhm.
annotation. I mean, you see, he's very notable for filing defamation lawsuits.
Yes, he is. Yes, he is.
Yeah.
Well, and I think also, but if you, which also kind of brings up, we didn't talk about it, but when people are doing satire, Saturday Night Live, they say horrible things about everybody, and but everybody knows it's fiction. Is that what? And are they protected by freedom of speech when it comes to using the name and likeness of others?
Parody.
Mhm.
Parody is a defense to um, defamation. Um, so it's parody is. I see someone uh, asked about the Dole commercial with monkeys and
Mhm.
yeah, parody. Something's considered parody. It's considered commentary, critique. It falls into that realm. Parody is a protected speech under the First Amendment.
Mhm. Somebody says they wrote a story based on a true story, but changed all the names. Do they still need approval of the person that the story is about?
And yes, I would say if they're identifiable, it doesn't matter about the name, um, but if a reasonable person can identify that person, if they know who it is, if anyone can determine who that person exactly is, they can be considered identifiable. So it doesn't matter about changing names, but that is a step. I would change the names. I would change the circumstances around it. I work with a lot of authors, and they want to tell these true stories, but they're concerned about defamation and the like. And yeah, you have to fictionalize it, change the setting, change the facts around the people, so that they're not identifiable.
So somebody asked, can they mention a book title and an author name and a biography where the person's work made a life-changing impact? In other words, if I'm writing a story about my life and I said I read this biography by James Smith about Einstein and it totally changed my life, that's not a problem because I'm assuming because I'm just saying that it had an impact on me, and I'm not taking anything from her work. I'm just mentioning their name in the context of something that I'm writing about. Is that true?
Oh yeah, it's all the time. Inspired by,
Hmm.
you see that all the time.
Cool.
Again,
Um,
the Copyright Act is not necessarily meant to restrict work, but rather to inspire new work. But it has to be new work.
it,
The transformative uh, use defense. Are there other creative elements contained in this work where uh, the old work or the other questionable work is just a factor of it? That there's more to it. It's essentially a new work. It's a brand new work that was only inspired by that.
mhm. Somebody asked, can people go up to the copyright.gov and download or request, or go to the Library of Congress and request work that's been put on the copyright site? Like, can I go look at all the screenplays that Aaron Sorkin is registered at by going to the Copyright Office or by requesting those properties?
I'm certain you can. I've never done it, but I'm certain you can.
Cool. Um,
Yeah.
the
I would more go to. I think I would look into the Library of Congress. I think you
right.
can. Yeah, you can find works in the Library of Congress.
Right. So the price of protecting it is telling the Copyright Office about it in that
Oh
sense.
yeah,
Cool.
yeah. They are the main library for our country. The Library of Congress.
If I want to do something talking about Madoff, I don't have to wait 70 years to do that, to write about him because he's a newsworthy guy. And
Well,
people have them.
he just
It's dead.
passed away too. Yeah.
Right. So you don't have to worry about defamation.
Mm. But again, uh, I'd always caution my clients to be careful of defamation of others in telling
that are
his
still
story.
alive.
Yes.
Yeah. So, but again, if you're going to do something that if you're going to go up against a giant, it makes good sense to be prepared.
Yeah, and not just defamation, but also disclosure of private facts.
Right.
Those are also actionable. Intrusion into seclusion, placing others in a false light, not necessarily an untrue statement, but placing someone in a false light in a negative context is still considered actionable.
Right.
So yeah, there's a lot of considerations.
Right. I emailed a request for permission to use a 3-second video clip of a movie QA panel. After several attempts, I still haven't gotten a response. What are my options to use the clip in a film? So if you want to use like a little clip of something and you can't get a response, do you go to an attorney and have them try to help you make the request as part of your documentation to say, I did try to get permission and I think this is a fair use application because it's in a, or how do you handle that when you can't get the permission that you need, no matter how often you reach out?
Well, I think it's good that you attempted to reach out. It shows your good faith. Again, the amount of the clip, 3 seconds, very small. I don't know how much of the whole of it is, but it sounds like it's a 3-second clip of a movie. So you're talking about a small fraction, and it also depends on how you're using it. But I think because it's such a small amount, fair use should apply.
Right. Somebody asks about the Dole commercial with monkeys representing Michelle Obama and Joan Rivers. Was that defamation? Or was that parody?
Okay. Yeah, parody.
Let's see. Is making a film inspired by song lyrics fall under transformative nature? If it's inspired by the song lyrics and you never use the song, is that okay?
Let me see. Is making a film inspired by song lyrics fall? Yeah, I would say yes. I mean, it's just an inspiration. Yeah.
Right.
It's got new creative elements. It's a whole different medium. I think you'd be protected there.
Right. So somebody asks, they have a story about their mother that involves the Catholic Church. Can the Catholic Church block a book? First of all, can anybody block something, or can they just punish you after it's released by lawsuit?
Well, they can get an injunction.
Mm-hmm.
All right, and that's a remedy in equity, and they can get that very early on. They can get a TRO, a temporary restraining order, mm-hmm. and then a preliminary injunction. These are at early stages of a litigation. When they file the complaint, and with that complaint, they can immediately request a TRO, an emergency relief, but it's a high standard they have to meet. But then through the course of the litigation, they can get a preliminary injunction from stopping the release of the book. And then ultimately they can get a permanent injunction to forever stop you from releasing that book.
So is registering your work at the WGA the same as registering at the Copyright Office, or does it provide exactly the same level of protection or not?
No. I get this question a lot. The WGA it's good. It serves as an evidence, but it does not provide you any legal rights. You obtain legal rights when you register your work with the Copyright Office. That's the only entity that counts. The WGA, a lot of people in the industry, they're like, oh yeah, I sent it to the WGA, it's registered with the WGA, but that gives you no legal rights. It really has no legal significance other than serving as a third-party witness.
And they throw away the stuff after 5 years anyway, so it doesn't even do that after 5 years. So.
Yeah, you have to do, I would, if anything, I wish I could just tell my clients, forget about the WGA, forget about it completely. You have to focus on the Library of Congress, the Copyright Office, copyright.gov. You go to that website, You can upload it. They have a great electronic portal, very efficient, but that's what you need. You need a copyright registration certificate.
Right. So how do you determine, so when it comes to determining what's a parody versus what is plagiarism, does it have to do with how much it's changed or how wild it is, or should it be apparent when you just glance at it that it's a parody? Like you mentioned the thing about Michelle Obama and monkeys. Like that's clearly a parody, just like the Saturday Night Live stuff is. But let's say I get Harry Potter and I just change Harry's name to Sally, or change Harry's name to Harry as in he has a lot of hair, Hairy. That's not enough of a change, is it?
That's a tough issue. I'd have to look into it a little bit more.
So the details that matter when it comes to the things like parodies and plagiarism, right?
Yeah, I would have to look into it a little bit more.
Yeah, I think it's a big question. I think Saturday Night Live has a lot of lawyers that help it figure out what's okay and what's not, frankly.
Oh yeah.
What's the so there's we should probably start wrapping it up. I don't know if you know the answer to this question, but there's this thing called Creative Commons where people who are creative professionals who want to allow their stuff to be used for free, they basically release it with a Creative Commons license that says free use, or you can use in everything except commercial purposes, or you can use you can't use it only nonprofit uses or whatever. So do those things have any kind of legal weight, or is it just, I've never seen any kind of lawsuit that talks about Creative Commons uses. I've never seen. So have you ever heard of anything? Have you ever heard of any case law that involves the Creative Commons attributions?
I'd have to look into it more, but I believe it's licensing. Yeah, and when you sign up, I'm sure there's some agreements you have to effectuate either through click through agreements. There might be some form of royalty payments. I don't know. I'd have to look into it a little bit more. But I believe it deals with licensing law.
Right. I think you actually have to put something special on the document or whatever.
Or they require you to give credit attribution if you use that work. That's the license agreement,
right?
Essentially.
And they put it on every version of the document. Well, this has been like one of the most informative events we've ever done, and I think one of the most important from a variety of perspectives. The interesting thing about choosing to do something, let's say you do want to do something that is going to make a lot of money. If you say that you're going to do an thing about Weinstein, and you're going to go and take a look at court cases that he was involved in, or you're going to do some of the most profitable things that people do are things that talk about news stories about people that were rich or famous that were already in the headlines, like the Menendez brothers, et cetera, et cetera, et cetera. So, it's kind of one of the few ways that you can make your work more instantly sellable is because you're talking about things that are in the news, and you're talking about things that especially if you're talking about people that are recently dead, unauthorized biographies that sell and so forth. So this is a really important event because it talks about how those right of publicity is, you have to understand that when you're going to be able to create something that focuses on that kind of work, which can be very, very, very profitable, but may also involve you in litigation. And I think the stuff that you talked about at the beginning, where you're talking about fair use and talking about when it's okay for you to use people's work without permission or without compensation, and when people can use your work without permission and without compensation, though, is very important, because the only thing most of us have, the only thing that we sell for the most part, is our creative work. So if we don't understand how to protect it, and we don't understand what we're allowed to do when we're creating it, if we don't know that we can write a story that involves Marilyn Monroe and Einstein, we don't know that when we can incorporate things from the real world into our pieces, it makes it much harder for us to figure out how to make something that ties into the world in which we live, I think, you know? So if people want to reach out to you, is there an email address they should reach you at, or can they use contact form at thesterlingfirm.com, or how does that work?
Sure. Yes. You can visit my website. You can also give me a call. My telephone number is 310-498-2750.
Hmm.
You can also email me, Justin at thesterlingfirm.com.
Cool.
And yeah, I'm happy to,
Cool.
answer any questions, consult.
You actually do
and
have like a monthly service. Like one of the things I think is interesting is you have a service where people can engage you sort of as like an ongoing counsel. So if I'm producing a film, I can sign up to get advice from you on an ongoing basis, and like big production companies do, instead of choosing to just pay like $500 here, $1,000 there, et cetera, et cetera, et cetera. So is the information on your website that talks sort of about like your monthly, I don't want to call it a subscription, it's not called that. What is it, a service agreement, or what is it?
It's a subscription program.
Okay.
But yeah, I've tried to provide affordable services to allow you, the client, to really control the legal costs. So there's a monthly subscription program starting at, I believe it's $99 for weekly consults. And then really the pro package is the most valuable, and that includes contract drafting credit, $50 a month that rolls over. And you can use that contracting credit for up to 6 months. So if you don't use it one month, it rolls over to the next month, and you can use the entire contracting credit that month.
So if somebody's really in the mood to do something, really wants to do an unauthorized biography, or really wants to do a documentary, or really wants to do a true life story, if they know that they're going to be working on something that's going to be involving a lot of these issues, and they need to be able to pick up the phone and go, is this okay? Then that might be a good option for them, because it's an affordable way for them to get the support they need at the beginning, middle, and end. Because that's my concern, is when I'm thinking about people that want to create these works, you can't wait till the end to get the answers, because you write all this content and it turns out that you do put somebody in a bad light. You make somebody the villain in a piece about the Hearst, about the Hearst family or something like that. You make it so you're accusing somebody of doing something really heinous, like ignoring child abuse or something like that. And it's like, it's hard to have to go back and rewrite the whole thing because you did something stupid at the beginning, right? Because you didn't know any better.
Right. And so I'm happy to be of service, and there's many different ways I can work with clients, and I try to be flexible and accommodate all my clients.
Cool.
So yeah, I'm happy to be of service. Feel free to reach out. Great. And I look forward to speaking with any of you.
That sounds really wonderful. Thank you so much for taking the time to meet with us tonight, and for putting together such a very detailed slide set. I'm gonna save it, and I'll edit it up just a little bit, although I think it's pretty clean, and then I'll send it over to you so that you can make it available any way you like, and then I'll make it available to the folks that are that I support on an ongoing basis. And I think it'll end up being one of the most important things that we release. I know that contract law thing has been a godsend to a lot of people, and your true life stories thing has been a godsend to a lot of people as well. So thank you.
Yeah, hopefully people enjoyed this presentation as well. I want to thank I want to thank everyone for signing on, and thank you, Nancy, again. And yeah, I really enjoyed doing these presentations. Thank you.
Thank you very much, man. I hope you have an excellent day or evening.
You too.
Bye-bye.
You too. Take care, everyone. Bye-bye.